So this is the second video in the Introduction to Contract series, which is all about what is an offer. So it's a good place to start. What do you think an offer in terms of contract law is, and what ingredients, if you will, do you think are required in order to make it an offer? So in this video, what we're aiming to do is to ensure that you're able to describe what an offer is, to be able to explain the law in respect of different elements of an offer, and also to use case law to illustrate the different elements of an offer. Now, talking about the AQA exam series for the A level, it's 2016, so if you're looking at this in 2030, you need to go back and have a look specifically at what your exam wants. But certainly in 2016, for AQA A-level exams, what we're looking at when we're looking at the law of contract is there are two different ways that you may be asked to look at something. You might be asked a very straightforward question, which is just to describe something. You might be asked to describe an offer. Describe the methods by which you can make an offer. And you just explain what it is with a definition, the elements of the law that we're going to have a look at, illustrate with case law, easy peasy. The other way that this might come up is you might be asked to discuss the stages of negotiation in a scenario, and you'll be given a scenario, 2 short paragraphs usually, where you will have to identify where an offer has been made. So you'll need to be able to spot it in the scenario. You need to give a very brief definition as to what it is, and give a case or two to support the point that you are making. So it's very straightforward, very easy, but you need to know your law in order to be able to spot it correctly. So what is an offer? Well, very simply, an offer is an expression of willingness to make a contract. And as we saw in the previous video, if you're in a contract, you are legally bound to do the thing that you said that you were going to do. So by making an offer, you're making the first declaration that you are prepared to be in that contract. Now, something we need to get rid of straight away is the idea of the buyer and the seller. It doesn't matter who is putting in money or goods or services, as long as we've got that exchange of promises or exchange of services or whatever it might be. It doesn't matter who makes the offer or who accepts it, as long as somebody within that agreement, one of the parties to the contract, makes an offer and somebody accepts that offer, and the acceptance is a mirror image. We'll look at all of that later on. But so it doesn't matter whether it's the person selling the thing or whether it's the person buying the thing who makes the offer. So let's have a look at some examples and some rules of law behind those examples. So an offer must be firm and capable of being accepted, and it's got to be clear in terms of the conditions which must be fulfilled. And an example of an unusual offer was in Carlisle and the Carbolic Smoke Ball Company. Now, we looked at this in the previous video, so we won't go through the case again, but you can see an excerpt of that poster. That is the offer, and you can just about read, a £100 reward will be paid by the Carbolic Smoke Ball Company to anybody who contracts influenza. And in the very small writing it says along the lines of, if you buy the product, use it correctly, and you still become ill. And you've even got that seal, the handwritten seal on the right hand side, that shows how serious they were. So because the offer was firm, it was capable of being accepted, and it was clear what must be fulfilled, this was an offer. This is Mrs. Carlisle. She did contract influenza having used the Carbolic Smoke Ball Company, and her husband successfully sued the Carbolic Smokeball Company for the £100 reward after they refused initially to pay it to her. She took the money, she won, fantastic. Her husband became very famous, and some years later she died from, ironically, influenza. So supermarket promotions may be an offer. So things like this that you see around the supermarket, but only if certain requirements are fulfilled and it's capable of being accepted. This isn't usually an offer. Think back to that poster we had a look at a moment ago with Carlyle and the Carbolic Smokeball Company. You had really specific instructions as to exactly what you needed to do, whereas this is much more vague. If we look at this Milo product, for example, I see that it's £30.99, but I don't know exactly what it is. I don't know how much of that product I get. I don't know what the product's used for. There's all sorts of things that I don't know, so I can't accept it through my conduct. I've got to go along to the shop and make an offer directly to them. So although the previous advert that we saw was a unilateral offer, an offer open to the world, this would be the start of a bilateral offer. It's actually something called an invitation to treat, which we're not going to cover in this video. That's something for a later time. But just to let you know, an invitation to treat usually comes before an offer is made, and it's an enticement. It's an invitation in to entice you and to encourage you to come along and start negotiating and start making an offer. So this is, I'm afraid it's not terribly clear, but if you have a look you'll probably see why that is. Argos accidentally listed these televisions, which the recommended retail price was $89.99. When they first started their website, they accidentally listed the televisions for £3. So my question to you, have a think about what we've said about Carlyle, the Carbolic Smokeball Company, and unilateral offers. Have a think about what we said about those supermarket promotions and bilateral offers, and the brief mention we had of invitation to treat. And I want you to tell me, do you think when Argos accidentally listed these televisions for £3, do you think that they had to sell them for that price? Well, it was all over the news when it happened, but as you can see by the website, this was quite a long time ago. The answer was that no, Argos didn't have to sell the televisions for the £3. What was decided was that by clicking on something and buy it now, or whatever, however you choose to buy it, you are making the offer, and it is for the organisation to actually accept that offer. So if you're familiar with buying things online, you usually get a confirmation email saying, thank you, we've received your order and it's on its way. That indicates that they have accepted your offer. The issue, if it worked differently, would be, well, if you have a look at the latest iPhone, for example, you could put 30,000 in your basket and click buy it now. But the problem would be, what if they didn't have 30,000? So if by you putting something in your basket on a website, if that was the acceptance, then there'd be loads and loads of breaches of contract and everything would fall apart. So when you actually click buy it now and you put your payment details in on a website, that's actually you making an offer, and the company that you're making the offer to then has to come back and accept your offer. So unfortunately, if you see one of these mispriced things like these Argos televisions, no, they don't have to sell it for that price. So there are some basic rules that you need to know about making an offer, and the first one is that it must be certain. This can be seen in a case called Guthing and Lynn. And in this case, the person making the offer said that they would pay an extra £5 if the horse was, and I quote, lucky. Unsurprisingly, the court held that this term was too vague. It wasn't certain enough. What does it mean by lucky? Now, in reality, both the buyer and the seller knew, because this was a racehorse, it was to do with winning races. But that was never disclosed. That was never mentioned. The only word that was ever used was lucky, and it wasn't clear what that luck entailed. And an offer can be made by any method at all. And as we've seen in Carlisle and the Carbolic Smokeball Company, very useful case that one, you can make an offer through an advertisement. It can be spoken, it can be written, it can be through what you do, your physical conduct, it can be through a text message, it can be through a message in a bottle, and it can be made to anyone, whether it's a group, an individual, a company, a representative of a company. It's by which you could make an offer. This is semaphore, which is communicating through flags. Although it would be difficult to do, you could make an offer through semaphore. And skywriting, there you have an offer of sorts in order to get into a contractual relationship. Although an unusual method, you could make an offer, indicate your willingness to be bound through skywriting. So the next rule that we have to have a look at, which also applies to acceptance, but we'll come on to that later, is that an offer must be communicated. You cannot stay silent about an offer for fairly obvious reasons, because the other person won't know that you're making an offer and therefore won't be able to accept it. Purely practical things. And for this we have a look at the case of Felthouse and Bindley. In this case, it was again about a horse. A nephew and uncle were negotiating between them by a letter to buy a horse. And the uncle said, "If I hear no more about him, I consider the horse to be mine for the set fee." And the nephew didn't reply. The nephew was actually holding an auction, and he was asking an auctioneer to sell off a variety of horses that he owned. But he did actually say about the horse that he was in negotiations with his uncle, "Don't sell that one, I've actually sold it to somebody else." But the auctioneer misunderstood and did actually sell the horse. So the uncle tries to sue his nephew and says, "We had a contract. I said if I didn't hear about it, the horse is mine. I didn't hear about it, so the horse was mine." And the court held there was no acceptance as there was no communication. And the same would apply to the offer. If you weren't told about the offer, then the offer doesn't exist. Another specific example is an auction. If you're not familiar with this, have a look on the internet, do a YouTube search and have a look for an auction. So in the case of Warlow and Harrison, again another horse was for sale without a reserve. The claimant made the highest bid, but the horse was actually sold to somebody else. The auctioneer took a higher bid at a later point from the horse's owner. And what was held was decided that the auctioneer was in breach of contract. So when you place a bid on something, when you put your hand up or when you shout out or however you place your bid, that is you making an offer. And when the auctioneer bangs the hammer down or says it's sold to you, that's the acceptance. And therefore, if you are at an auction and you place a bid and the auctioneer says it's sold to you, that at that point the contract is made and the auctioneer is not allowed to sell it to anybody else. Now, in some auctions you can place a reserve on an item. So if you take your prized possession along to auction, you can set a minimum that this item can go for and be sold for. and if it doesn't reach that minimum, then it won't be sold. So that's a slight exception to the rule. But in this case, there was no reserve, there was no minimum set. So when the auctioneer said it's sold to you, that's when the contract was formed. So there was a breach of contract. The other thing that you need to know about is something called a tender. What happens with a tender is big organisations, like in this particular case, Blackpool Borough Council, list on websites and on big lists that they have certain jobs that need doing, and they're usually quite expensive jobs, you know, hundreds of thousands, millions of pounds jobs, and organisations are invited to put in their bids and to say, we will do this job, we will do it in this way, and it will cost you this much. And by putting in these bids, that is the organisation making an offer. And it's for the organisation that invited these offers to be made to accept whichever one they wanted to. So what I have done is I am inviting tenders. It's to AS law students, and I'm looking for a teaching assistant to help me make coffee in the morning, to ensure that the department is stocked with biscuits, and to make me 3 appropriate comments per day. You need to do it in writing, and please include your price and an overview of why you should be selected. And the deadline is the end of Friday, for example. So that's me inviting these tenders. You come along and you put your offer in, your bid in, and then I would choose who I wanted to do the job and accept that offer. So overall, that is the law on offer. What we've had a look at and what you should be able to write a question and an appropriate revision answer for is: what is an offer? The methods by which an offer can be made, what is a tender, and what is an auction.